Good evening, Asia. Good morning, America, and good afternoon, Europe. Welcome to all of you, dear friends, and thanks very much for the fidelity towards the encounter. So welcome to the 15th Global Digital Encounter. I'm not so sure whether you can see me, but I guess that at least you can hear me. I am Manuel de Santos. So before jumping into this fascinating topic that it is going to occupy us today, I would like to honor one of the professors I have admired the most in the last 30 years, a professor who regrettably left us some days ago. I'm talking about Professor Luigi Ubertazzi. Professor Ubertazzi worked, I should say, tirelessly for more than half a century, illuminating us in all areas of intellectual property, but also in advertising, in unfair competition, if I remember well, also in banking. A professor who understood the value of working in a holistic way instead of closing himself in silos, something we are promoting again and again and again in the encounters. So our Global Digital Encounters family would like, with these humble words, to render homage to Professor Luigi Ubertazzi today, to thank him for his invaluable academic contribution, and to send also a very respectful and, I should say, an affectionate greeting to his family, but most especially to our dear Professor Benedetti Ubertazzi. I know you are attending all our encounters, Benedetta. I know you are there, so our hearts are with you. Please receive, on behalf of Professors Laurent Manderieu, Fernandez Laschetti, and myself, our most sincere admiration and friendship. So you know very well that the aim of the encounters is to become a think tank, to become a place where discussion is promoted, to become a place where scholars and professionals from all over the world reflect on the future of our IP systems in a cognitive era. Today, we will discuss a fascinating topic towards a more predictable legal framework for cross-border IP disputes. And most especially, we will discuss the International Law Association Kyoto Guidelines. The case is that intellectual property controversies and intellectual property disputes become more and more cross-border in the context of the fourth industrial revolution. This is something we all know. And the enforcement of IP rights in this global environment raises new and complex challenges. Challenges if we compare to the traditional molds, to the traditional ways of solving conflicts through national courts. The solving conflicts procedures still differ widely from country to country, and this fosters the development of an environment which is deprived of legal certainty, an environment which also severely affects the enforcement of IP rights all over the world. So all in all, this means that the adoption of model provisions on the private international law aspect of intellectual property become an urgent matter. This 15th encounter will discuss the main lines of the Kyoto Guidelines, who were agreed on December 13th, if I recall well, 2020. It was agreed by a group of almost 30-something renowned scholars from almost 20 jurisdictions, and they were under the auspices of International Law Association. And today we will have the pleasure to have among us the speakers, the moderators, the co-rapporteurs, the members of the group, of this distinguished group. So it is my great pleasure to introduce to you to my dear friend Pedro de Miguel Asensio, who is Professor of Private International Law at the University Complutense of Madrid. He will be the moderator. So good afternoon there, Pedro. And it is my great pleasure also to introduce our panelists, Professor Marketa Trimble, who is Professor of Intellectual Property Law at the University of Nevada in Las Vegas. So good morning, Marketa. Professor Toshiyuki Kono, Professor of Law of Kyushu University in Japan. Good evening there, Toshi. Good evening, I would say good night. It's midnight in Japan. And finally, my dear friend, Professor Axel Metzger, Professor of Civil and Intellectual Property Law at Humboldt University in Berlin. Good afternoon there, Axel. So thanks indeed to all of you, dear friends, for having accepted to be with us today. You belong now to the family of the Encounters. And I'd like to give the floor to my friend, Javier Fernández Laschetti, coordinator of the Encounters. He will talk briefly, and then he will give the floor to Professor De Miguel to start the Encounter. Enjoy the meeting, please. Javier, you have the floor.
Thank you, Manuel, and welcome you on board once again after this summer that has passed so rapidly. We are back to business. And we are very, very happy to have you here again. Almost all has been said by Manuel. You know about the importance of this encounter, the importance of the topic, because intellectual property is international by nature, and it is true that that there has been many efforts to achieve some harmonization, maybe at a regional level, as it happens in Europe, but also at a global level. But it is true that there's still some pending issues regarding litigation and how to solve conflicts in that international environment with all the risks and problems that it may have. So I'm very happy to be here. I'm very excited to be here to hear our speakers, and that's all I wanted to tell you, apart from what I say all times. I mean, remember that you belong to a family. We are a community, so please participate, raise your questions, share knowledge, share documents. We'll be happy to have your participation with us. Thank you very much. And now, Pedro, the floor is yours. Thank you.
Okay, thank you very much. Well, first of all, I would like to say thank you to Professors De Santis, Mandier, and Fernández Laschetti for choosing this topic as one of the topics to be discussed in the global digital encounters. And as I think all the attendees have had the opportunity to have access to the main result of our project, which is the ILA guidelines, and among the text documents that have been provided for the discussion, you can see the full text of the guidelines plus the comments that were published with them. As Professor De Santis said, this has been the outcome of a project that has lasted around 10 years under the auspices of the International Law Association. You can see that the result is a complete set of rules that covers international jurisdiction, choice of law, and recognition and enforcement of judgments. Some of those rules, I will also say, that are really rather innovative, because it's not that they are not, let's say, international texts addressing these issues, but even that the document covers some issues that have not also been dealt, I would say, at national level, dealing private international law issues. For example, I would like to stress in this regard the provisions on jurisdiction and choice of law issues raised by collective rights management. So I think that's particularly a very innovative aspect of the guidelines. But in order to follow the traditional content and approach of these encounters, I would like to start by posing some questions to the panelists. My first question will be just an introductory one, just to Professor Toshiyuki Kono can give us his view on the significance of the guidelines in the context of the previous projects in this area, and in particular also in the context of the recent developments. I'm thinking, for example, of the 2019 Hague Judgment Convention, where precisely IP issues were excluded from the convention. So let's let's say, the most recent achievement in the context of recognition and enforcement of judgments, but this area was excluded. So I don't know, Dr. Kono, if you can give us your overall assessment of this issue, the significance of the guidelines.
Thank you very much. First of all, can you hear me?
Yeah.
Oh, thank you. Thank you very much for having me. It's a great pleasure to be with you today. Well, the idea to discuss about intellectual property and private international law started with the failure of the negotiation of the Hague Judgment Project, which started in 1992. And after almost 10-year-long negotiation, they decided not to continue. But one of the biggest challenges at the time was intellectual property, and our colleagues, also the members of our committee, actually somehow rescued the issues, and they started academic projects, and this the first of all the American Law Institute, and then the Max Planck Institute, CLIP Principles, and then Japan Korea the project, and also myself organized legislative projects, and then so although the issues is very important, the legislators did not react properly, so that the lacuna was filled by several groups of academics, and this ILA guideline is actually the more comprehensive, not region-specific, comprehensive global output of the discussions, which covered almost all major jurisdictions. And this project, well, as Professor Miguel de Asensio just said, that the new Hague project on the recognition of enforcement of foreign judgments, the IP matters, it was actually on their agenda at the beginning, but at the end of the discussions, negotiations, they decided to exclude this topic. So there's still lacuna in international instruments. So we believe that this lacuna can be filled with our guidelines. So maybe I should stop here.
Thank you, Professor Kono. I would like to also give the floor to the other two speakers, to Marketa Trimble and Axel Metzger, just in case they want to react to this. I don't know, Marketa, please.
Thank you, Pedro and Toshi. It's wonderful to see you. I think what Toshi said is exactly the case, that this was a very important project precisely for its geographical scope. So the members of the committee really came from a variety of countries. It was not geographically focused, and it showed the possibility of people from really very different jurisdictions to agree on some of these issues. The second thing that I think was really important was also that the committee was able to update some of the issues. So not only that it dealt with some new issues that the previous projects had not opportunity to address, but it also updated some of the issues that have been discussed in the previous projects, particularly in light of some recent developments in law. So for instance, in the United States, certainly the developments in general jurisdiction law was very important for the present project.
Thank you, Marketa. And Professor Axel Metzger, maybe you can also add something on this.
Yeah, thanks a lot, Pedro, for giving me the floor, and thanks a lot for the organizers of the encounter. I'm happy to be here and happy to see my colleagues and to discuss with all of you. I think most have been said about the general background of the project. Maybe one thing may be interesting to add. Professor Kono mentioned that there had been regional projects before, which were really provided in-depth analysis and very concrete proposals, but written in front of the background of the given legal culture. So the American Law Institute guidelines were very much based on experiences from North America, whereas the CLIP principles were very much inspired by European texts and jurisdiction. And what we try to do in the International Law Association in this, as Marketa rightly said, really international group was to draft compromises, not only for some of the issues where we had different outcomes in the regional projects, but also with regard to the style of the guidelines and the outcome. The Kyoto Guidelines really reflect this global ambition to draft compromises which may be used in many regions of the world. So that was a fascinating endeavor, and also it was really inspiring to work together with colleagues from those different jurisdictions. And I'm not sure whether Professor Kono mentioned it. The guidelines are published in a special issue of GP Tech, an open access journal that you probably know or you should know. It's issue 1 of this year's GP Tech edition, and the guidelines have been published together with comments and examples and references to the older projects.
Thank you very much, Axel. Now I would like to move a little bit more towards the content of the guidelines, and I would like to raise the issue coming back to the let's say to the title of our session today, which is towards a more predictable legal framework for cross-border IP disputes. I would say that an area where this is particularly relevant, because cross-border disputes are very common, or let's say activities are in principle almost always international or even global, is, let's say, the online context, so online activities. So I would like to raise the issue of if you can stress or point out some features of the guidelines that may illustrate that this instrument can improve the regulation of cross-border IP disputes arising from online activities. Maybe Marketa can first address this issue, please.
Thank you, Pedro. So indeed, cross-border online issues were on the mind of the committee quite a lot. Of course, any conflicts on the internet are problematic because of the ubiquitous nature of the medium and the ubiquitous nature of potential infringements and other features of the disputes. When you think about it, in the current environment, it is very difficult, or it can be very difficult, for IP owners to enforce their rights on the internet. Usually, IP rights owners have to resort to one jurisdiction. They have to file their case in one court in one jurisdiction and pick the jurisdiction and the law that will help them the best it can to pursue their rights. So the committee tried to make sure that it really captures the recent developments and makes it feasible for IP rights owners to enforce their rights across multiple jurisdictions. So the first, of course, step is to open up more courts of general jurisdiction. So the guidelines still, of course, maintain the typical general jurisdiction provision, which gives general jurisdiction to the court of habitual residence of the alleged infringer. But in addition to that, it also opens up a new court of what we might see as general jurisdiction. And that is a court, according to Guideline 5, in the place where the alleged infringer acted or initiated or furthered the alleged infringement. And that will be a court where an IP owner can also bring a claim that will be territorially unlimited. So it is listed as specific jurisdiction, but again, it has feature of general jurisdiction in the sense that the territoriality of the claim might be unlimited. when you think about it, right, where the act was initiated or from where the act was furthered, we can think of the place where the alleged infringer placed content online, from which they run the server and so forth. So that's in terms of jurisdiction. And then, of course, mirror image of that is a provision on choice of law, where again, it might not be of much help to be able to go to these different courts if you still have to claim, and in some cases even approve, foreign law or law of multiple jurisdictions. And therefore, Guideline 26 includes a special provision on the law applicable to ubiquitous infringements, to infringements that happen typically online in multiple jurisdictions. And there we see that the guideline would permit the court to apply only a single country law. So in Guideline 6, the law would be the law of the country, of the state, having an especially close connection with the global infringement. And the guideline gives some of the factors that the court would consider to figure out what is the state with the especially close connection with the global infringement. And there is a clause that allows the alleged infringer to bring proof to the contrary, right, to show that certain countries' laws should actually not be encompassed with this general provision. But in general, it would allow an IP owner to go to one single court in the place, let's say, where the infringement was initiated, and in that court bring a global infringement case using only one country's law, right, a single country law, which would, of course, significantly simplify the infringement proceedings. It would significantly simplify IP rights enforcement. So that's, in a nutshell, I think, the major features of the approach of the guidelines to ubiquitous infringement on the internet.
Okay, thank you, Marketa. I don't know if perhaps Axel or Toshi, would you like to add something on this?
If I may, well, I don't. I have nothing substantial to add to Marketa's explanation. Just I'd like to introduce a case, a real case, and in my country. There was a website which is closed already from 2016 to 2018. On this website, thousands of Japanese animation manga were available for free. And almost at the end of their activities, the number of monthly users were 100 million. And the owner. And all of a sudden the website was closed because a lot of controversies occurred. And then what they discovered later was that the contents were provided by the Cloudflare, it's a company located in California. But the server of this website was located in Ukraine. And the server was contracted by a Swedish service provider. And the owner disappeared. Owner somehow it was identified, but he was recently arrested in Manila in the Philippines. So, but this liability, the main issue in my country was that the criminal aspect, the compensation and injunction were not main issues as a discussion point. But this case clearly shows the potential future cases, and it shows its complexity. Just I wanted to share this case with you. Thank you.
Thank you, Toshi. Axel, I wonder if you want to add something on this.
No, I keep quiet on this, and I'm curious for your next question.
Okay, thank you. Yeah, okay. Well, the next question, I think if there is a topic in which traditionally national systems have diverged regarding choice of law, that is the one of initial ownership regarding IP rights. And I think that's a very key, very relevant issue. So And I also think that those differences in national law were reflected also in previous projects where solutions were also different. For example, comparing the European CLIP project with the American Law Institute principles. So I would like to ask, maybe perhaps to you, Axel, first, if you can discuss what is the approach of the guidelines on this, because I will say that this is quite an innovative approach, and it's also an approach that has, let's say, been able to achieve the consensus of people coming from different backgrounds on different projects. So if you can elaborate a little bit on this, please, Axel.
Yeah, thank you, Pedro. Indeed, initial ownership, especially in the field of copyright, has been one of the most controversial issues in conflict of laws of intellectual property. The problem here is that many jurisdictions, also my home jurisdiction, Germany, adhered traditionally, or still do, to the territoriality principle in intellectual property and apply this principle also to initial ownership, meaning that if you want to bring a case for a multi-territorial IP infringement, copyright infringement, you have to plead for each and every country whether you are the right owner and where the rights were allocated first and how the rights were acquired afterwards, which may be burdensome because you have to apply some laws at the same time. So that's the territorial approach, whereas other jurisdictions applied some sort of a lex originis approach, specifically the United States, traditionally also France and Portugal, but France shifted away from this approach in the last years. And according to this lex originis approach, it would be possible to determine the law applicable to initial ownership in accordance with the law of first publication or the law where the work has been created. There are different versions of this lex originis approach. And these different traditions were also reflected in the regional projects that preceded our project. The American Law Institute principles adhered to a lex originis approach, whereas the CLIP principles confirmed the territoriality principle here. And that was something where within the International Law Association, we felt we have to get a step ahead and have to find some sort of a compromise, which was not so easy because there are good arguments for both sides. You may say the territorial approach is difficult and burdensome and produces a lot of transaction costs. On the other side, it's one of the arenas where different concepts of copyright law at the end come really up. So, for example, in a movie production, do you take the movie producer as the copyright owner, or is it the creative personnel who at the end should be owner of the copyright? This is something where you may have different philosophies. So for example, art house movies in Europe, you may put more weight on the director, whereas on a producer-based model in the United States, you may rather look on a concentration of rights. So this is something which is not just a doctrinal issue, but there is strong economic and maybe also philosophical background behind this. Now, in the Kyoto Guidelines at the end, it's Guideline 20, we came up with a compromise based in principle on the lex originis approach, but we are not using the place of first publication, but the place where the work was created, so where the author was habitually resident at the moment of creation. So it's a specific kind, if you want, of lex originis approach. But then still, if countries see a strong policy behind their allocation of first ownership, it may be possible to plead for those specific countries that a different allocation may be applied. So in a way, there is a principle which is lex originis, but you may still plead on a territorial basis, and we were had heated debates over many evenings, and at the end were glad to come up with a compromise. So this is one example where one can really see that the ambition of the project was to come up with truly universal guidelines.
Okay, thank you. I think it was very clear. I don't know if Marketa or Toshi, would you like to add something on this?
I would just add that one thing that's really amazing about the guidelines is that they are very forward-looking, right? So we have to realize that many of the private international rules that are used in courts all over the world are used in the current setup. But the guidelines project a world where we would have a much easier cross-border litigation, and therefore courts would deal with many more of these cases, and it would be easier to handle these cases. And one has to wonder whether the approach of courts would fall much easier with some of these guidelines in a situation where they would deal with many of these cases. So going back to the ubiquitous online infringement cases, one could picture how a court suddenly not faced with 20 different countries' laws for infringement, but only one perhaps, would find it maybe more appealing to look at this guideline and use the law of the state with the closest connection to the creation of the work for copyright ownership.
Okay, thank you, Marketa.
Well, well, nothing important, but Axel just said that it was a bit difficult. It was difficult. It was not a bit difficult. It was very difficult to find a solution. We discussed many times. We spent a lot of time for that, but I'm very happy that we came to a very nice conclusion. Thank you.
Okay, thank you. So I think we still have 5 minutes before giving the floor to the audience. So I would like to pose one additional question to you. This is a more general question. I mean, I wonder, what do you think are the possible means for the guidelines to influence the regulation on these issues in the future? What do you think? I mean, are the means by which the guidance can really, let's say, make a change or contribute to improve legislation in this area? Perhaps Marketa, would you like to start?
Thank you. So as was mentioned earlier, in the United States, we already had the American Law Institute project on the same topic. However, the project was drafted some years ago, and the guidelines certainly updated the rules and again made them more globally acceptable, hopefully. I think in the United States, given the role of courts in shaping some of these rules, the guidelines can really assist the judiciary in enlightening the judiciary about the approaches that other countries might find appealing and about possible solutions to some of these issues. And again, for instance, when it comes to jurisdiction, the development in the United States in the rules of general jurisdiction in the past 10-15 years suggests that it might actually be much easier now for the United States and for US courts to accept some of these guidelines as really feasible solutions in the United States.
Okay, thank you, Marketa. Axel, maybe you would like to add something on this?
Yeah, maybe I can add that indeed the previous projects, the CLIP principles, for example, they were cited from time to time from the Advocates General of the Court of Justice of the European Union, and that is one field, I guess, where the Kyoto Guidelines may also play a role as an inspiration for courts, for international tribunals, especially for those who have really to decide on an international basis. So arbitration may be one field, and also we hope that the guidelines may be used as a blueprint for international organizations. We were in close contact to WIPO during our project and also to the Hague Conference, and we still have some hope that the guidelines may influence the future work of the international institutions. So this could be different fields of where the guidelines as a soft law instrument can can be helpful.
Okay, thank you.
Just a few words to add to Axel's response. The Hague Conference on Private International Law and the WIPO jointly published a guide for the judges to deal with international intellectual matter issues. And this is a very sort of introductory, let's say, it introduced the issues and it tried to explain as clear as possible how to deal with this. And then our guidelines would be perhaps the next step to for those who understood what the issues are. So I think the international organization started to recognize the importance of the issues finally. And this guideline will be already translated in 5 languages, and it will be translated in more languages, and so that it will be more easily accessible to more lawyers and the judges in the near future.
Okay, thank you very much. So I think we will now move to the questions posed by the audience. So first of all, we have 2 questions from Burkhard Goebel. First of all, thank you very much for raising, well, 2 very interesting questions.
Well, thank you, Burkhard Goebel, a partner at Hogan Lovells, leading our IPMT practice globally. Thank you to all the panelists for inspiring, insightful, informative presentation, and in particular for the hard work you have been doing to come up with the guidelines in the first place. I've been working in cross-border litigation for the last 25 years and I've seen a lot of it, so it's interesting to see approaches how to deal with these problems which we face every day, and in particular our clients face every day. So thanks for the work. As to the questions, you mentioned in the very beginning there were concerns in previous legislative work, IP was expressly excluded, and there was a reason for that. Do those reasons still stand, and wouldn't they still be in a way of endorsing the guidelines more broadly? Because we see, I mean, whenever there's an attempt to harmonize, in particular IP conflicts between the major industrial players, it's close to impossible. So do the concerns still stand, or do you see a change in the political environment that makes you feel more optimistic about it? That was the first question, and the other one is a more technical one, the typical race between the defendant and the plaintiff, between the declaratory judgment action and the action for injunctive relief. How do you resolve that in the guidelines? Is both equally available, as would be in some jurisdictions, or does the action for injunctive relief trump the declaratory judgment action, therefore making the so-called torpedo impossible? That's all. Thank you.
Okay, thank you very much for the 2 questions. Any volunteer for the questions, or I can.
If I may just briefly, in terms of the U.S. Approach or U.S. IP bar approach to rules of conflict of laws or private international law and IP litigation, I'm afraid that not much has changed. I don't think as much will change in a short period of time. But I think we have to start somewhere, right? We have to start somewhere. And certainly the political environment plays a big role here too. Also, education plays a huge role, right? So we still produce a lot of lawyers who have no basic understanding of conflict of laws in the United States, which is tragic to say the least. And on the other hand, right, we see a rise in awareness about these disputes. We see some very well publicized disputes, including our anti-suit, anti-suit injunctions. So my hope is that people will become more aware of this, and that eventually we will come to the place where there will be no longer business solutions available to deal with these disputes, right? And we will have to turn to judicial solutions. and maybe the idea of committee will rise again.
Thank you.
Okay, then maybe I can also address briefly the second question, because I will say that the guidelines themselves do not differentiate between injunctive relief and declaratory actions. In principle, I mean, the grounds of jurisdiction, I will say, are the same. I guess an issue which is relevant to assess probably the limits of a race to the most convenient forum is that, in principle, let's say most jurisdiction grounds are limited in scope in territory when it comes to territorial scope. I mean, other than the defendant domicile, let's say, of the place of origin of the activity, the jurisdiction granted is limited to the territory of the, let's say, for example, of the country where the activity is taking place or the infringement is taking place. So that means that going to that court will not grant you the possibility to block a claim brought in a different jurisdiction, because the jurisdiction of the first court will be limited to its territory. Provided that is not the case, that you have not brought the case before the defendant domicile or before the place of origin of activity, because those grounds of jurisdiction grant unlimited jurisdiction. So and it's relevant to assess this torpedo risk, I would say.
If I may, and just as a direct follow-up question, without wanting to monopolize it. Now, how do you define a place of origin? Because, I mean, if you look at, for instance, European rules or the case that Professor Kono just outlined, where the server is, where the money goes, where the infringement goods are manufactured, where the user base is, so I mean, where it's directed to, I can give you 10 more places. They could all be, so what is the origin? How broadly do you understand that concept that could open up, well, let's say 10 jurisdictions in addition to the defendant's domicile?
Well, I mean, it's defined in, I would say, in Guideline 5A, I think there is some sort of definition of that ground of jurisdiction. So coming back to your question, for example, that wouldn't be the place where the server is located, because we think that the server may be located everywhere. You can choose a server in a jurisdiction which has little connection with the activity. So what this guideline says, if my recollection is correct, says something like, is the state where the alleged infringer has acted to initiate or to further the alleged infringement. So, I mean, it requires some sort of special, substantive, and significant connection of the infringer to that place. So the idea is to try to prevent the possibility for the person to try to seek, let's say, some sort of heaven with little connection. So we are looking for substantial connection to that place. And in most of the situations, probably that place will be, that's also the case, for example, in the case law of the Court of Justice, will be the place where that person is domiciled or has its establishment, usually.
Actually, if I may intervene, this is one of the, let's say, scenarios where I would wish that the Court of Justice of European Union would look into the Kyoto Guidelines, because, as you know, the court accepts the mere accessibility to a website for giving infringement jurisdiction. This is something which we go against in our Guideline 5 and say there must be a more substantial connection to prevent that we have some jurisdiction to feel competent which have a very loose connection to the case. So, but let's see whether the court one day will pick up our suggestions. Another point I wanted to make, we spent a lot of thought about coordination of proceedings. So what happens if you have two courts, which one has the declaratory action for non-infringement, the other one has the infringement proceeding, which is complicated on an international level if you're not within the Brussels system, for example. And this is Guideline 17, and in principle we go for the lis pendens rule. However, we allow for the second court ceased to continue its proceedings if the court first seized does not act within a reasonable time. So, I mean, you may have more experience with really these international competing fora. That's a complicated issue, but we would be glad if there would be more coordination in this.
Thank you. Thanks very much. We appreciate it.
Thank you. Alvaro, I don't know if there are any other speakers that want to intervene directly. Or...
No, next question by Thiago. He says it's okay. He's happy with the written question. Okay. That's on the chat. Okay, and yeah, so Iago raises also a question which deals with, I'm just reading it now because he said that no doubt the guidelines can simplify how to deal with cross-border online IP infringement issues. But however, how would that help in the enforcement of an eventual decision against a national or a third country that has not been the selected jurisdiction and that is the national law, and its national law has not been applied? How the guidelines deal with this practical issue? So I guess he's raising the question of once you have a judgment against someone who is not in the jurisdiction and maybe has no assets in the jurisdiction, to what extent the guidelines can be helpful in this case. Perhaps Marketa can address this issue, which I think it has to do with the possibility to recognize and enforce the judgment.
Okay, so yes, thank you, Pedro. So the section on recognition and enforcement, Pedro could actually talk at length about the section because he and I were very involved in the section and drafted the comments on it. But to answer the question briefly, the section on recognition and enforcement, of course, supports all of the previous rules guidelines in the sense that it is expected that judgments that will be rendered based on jurisdiction choice of law rules in the guidelines would then be recognized and enforced in other jurisdictions. So a jurisdiction that would be recognizing, enforcing the judgment from another country, as long as the judgment followed all those rules, would of course recognize and enforce the judgment. So that's the expectation. The grounds for non-recognition and non-enforcement are in Guideline 34, and all of those rules on the recognition and enforcement of foreign judgments are drafted really to make recognition and enforcement really available in most cases. We even have a provision about adaptation of foreign judgments, right, to make sure that courts are able to adapt a judgment from a foreign country if the enforcement so requires in their jurisdiction. But in general, right, the expectation is that the judgment would be recognized and enforced abroad, which is again why, of course, it would be ideal for these guidelines to be adopted, if not as soft law, maybe perhaps as another type of instrument that would really bind countries, and the countries could rely on each other in the sense of recognition and enforcement.
Thank you, Martin. Then we have, I don't know, Axel or Toshi want to add something on this? Or? Okay. Then we have another question by Hiroko Onishi that asks to what extent the criminal sanction is effectively enforced where infringers are not in the same jurisdiction. Well, I think this question may be important because it raises the issue of the scope of our guidelines. Really, the scope of the guidelines is limited to civil and commercial matters. So that means that the guidelines are not intended to apply, let's say, to criminal proceedings, not to determine jurisdiction, not to determine enforcement of judgments, because in practice, it's true as the question raises that criminal judgments are in principle not cannot be enforced abroad. So I mean, there is not a system of recognition and enforcement of judgments when it comes to criminal judgments that can be compared to the situation regarding civil and commercial claims. So and the guidelines are limited to civil and commercial claims. So and they are intended precisely to, as Marketa discussed, to make easier to enforce a judgment. For example, you have a compensatory judgment, and you need to, let's say, you have to enforce the judgment in order to obtain the money. You can go with the judgment to another jurisdiction trying to enforce it, but that's really a civil and commercial claim. It's not a criminal claim, and therefore the guidelines couldn't be applicable to that. So
My answer would be that the guidelines could be of no help in that regard, but never was the intention of the guidelines, because basically these are, let's say, two different worlds, so to say. I mean, because provisions or even conventions dealing with recognition and enforcement of judgments in civil and commercial matters do not cover criminal aspects. So that's it. So, okay. Perhaps an issue which is also of interest, maybe, is in the current context, taking into consideration some of the, let's say, most notorious cases, is I don't know if you can elaborate a little bit on how the guidelines deal with this issue of online injunctions or injunctions against online activities. I mean, because there is this also, for example, in the case law of the Court of Justice, these cases in which the claimants seek to obtain, let's say, the removal of the information. So, and there's the discussion of what circumstances have to be present for a court to be able to decide on the removal of information. That is something that is going to affect the availability of the information worldwide. And that's, let's say, that's very exceptional remedy, because it's not limited to a country. And here we're discussing of rights which usually are territorially limited, even if we are also dealing with activities that may be infringing rights in several countries. So I don't know if you want to say something on this. Perhaps Marketa, on this idea of the scope of injunctions against online activities and how the guidelines address this issue.
Yes, thank you. Well, this was actually also a slightly controversial issue in the sense that there are some jurisdictions where injunctions may be granted that cross borders if it is so required to protect IP rights at issue. The result of our discussions is Guideline 14 about the scope of injunction, which clearly states that the scope of an injunction is limited by the extent of the jurisdiction of the particular court that issues the injunction. And in addition, it says that the scope shall not be broader than necessary to protect the intellectual property rights enforced. So it seems reasonable to assume that a court would, for instance, limit the territorial scope of an injunction if the court's jurisdiction were limited, for instance, only to the court's own jurisdiction. And of course, these days with new technical possibilities and more reliable geo-blocking, one could assume that courts would be able to design territorially limited injunctions.
Okay, thank you very much, Marketa. So I think now we have now come to the end, because we don't have much time for us to add anything. I don't know, just if I just wonder if any of the three of you want to say any final word on this before giving back the floor to the organizers. Okay, so well, yeah. I think it has been a fruitful discussion, and it has been. Sorry.
I think Marketa wanted to say something, and
okay.
And in fact, if I may, Pedro, I would be delighted knowing from all of you, having the opportunity to have you here, which is unique, to get in a nutshell. How did you feel while dealing with such a fantastic project? Which goes much further than intellectual property and private international law. We move into a world where we need guidelines everywhere. And this is a beautiful example of how more than 30 people coming from so many different backgrounds and nationalities came together and provide such an extraordinary text, which I understand as not as a closed text, but rather as a text which should be able to evolve in the future, yeah, without any need of having another guidelines in 20-25 years. Sorry for being long, but I'm very excited of knowing your final reflects on this.
Okay, I don't know, Toshi, Axel, or Marketa.
Well, just a few words. at the very beginning of this publication of GP Tech, you can find a list of committee members, and three of us and actually four of us had really great discussions with the leading experts in the field. I was very honored to have worked with this. I think that this is absolutely the best, let's say, best team for these topics, and I can't imagine the better team than our committee. So it was a really outcome of the very rich discussion for more than almost 10 years. So although the article is rather concise, but that was our intention, to make it very concise and a clear and user-friendly material. So I hope that all participants today would enjoy reading it. Thank you.
Thank you very much, Toshi.
Maybe if I can take up the point Manuel made about, is this a living, in a way, a dynamic document? We would very much hope so. I mean, I guess when we started the project, it was clear that only academics will find the time to have all these meetings we had and really to work together on this. However, we always try to be in discussion with practitioners and to see what's really happening out there. And when I listened to the intervention of Burkhard Göbel today, I thought, well, we would very much appreciate to hear from practitioners, from legal practice, if our suggestions prove in reality whether there is room for getting better solutions, and we would certainly be glad to take up suggestions, and especially if there are practical cases, to comment on these cases in legal reviews and to take it as an intermediate step in a continued discussion. So everybody who makes use of it or has ideas, contact us, and we'll be happy to continue in a way, even though the guidelines are not there, but there may be further publications.
If I may just add, indeed, it was a true honor to serve on this committee and work with the leading experts in this field. A dream for anyone who does comparative law and private international law, of course. I cannot believe that Hollywood hasn't contacted us yet, because I really think a movie, a motion picture, full feature should be made about the work of this committee, for sure. If I may just say, as Toshi pointed out, the list of all committee members is in the publication. I would just like to say that I'm very thankful to Professor Jane Ginsburg and Professor Rachel Dreyfus, who were on the committee and very crucial for the US membership on the committee. So indeed, a great honor to be on the committee.
Okay, thank you very much. I just can say, I mean, the same. I mean, that it was really a great honor. It was really an extraordinary experience. It has lasted for 10 years. Really, I think that as it has already been said by Manuel and by Axel, I think that the result is yet dynamic, because also we are dealing with a reality that is changing. So, and it's also, to a certain extent, is a set of compromise solutions. So, I mean, they are intended to be even probably adapted when applied to local jurisdictions. So, and it's different, it may be different contents they are taken into consideration in local jurisdiction, and for example, when drafting an international instrument. So, I mean, so they are there to be adapted and to be adapted to different circumstances. So I think now we have just come to the end and to the time we had been assigned. So I would like to give back the floor to the organizers, and particularly to Professor Mandelier. So Laurent, the floor is yours, please.
Thank you very much. I would wish to warmly thank our speakers and moderator for this super brilliant moment that we have spent together discussing what will be important for us in private international law in the field of IP in the next 20 years. So this is fundamentally the idea of the global digital encounters. And precisely, I would wish to not only to all of you, as I've done so, including our participants, for the brilliant questions, but also to reflect on one comment that has been made by Marketa on the link with the internet on jurisdiction. We at the Global Digital Encounter give a lot of importance to the issues of the force. You have mentioned that in the committee you had Professors Ginsburg and Rochelle Dreyfus, who were also speakers and form part of the faculty of the Global Digital Encounter. So fundamentally, we intend to be not really the watchdogs, we can't be so, but the academic witnesses of the changes. And this is why for our next Global Digital Encounter, we will dedicate it to a topic that has been covered in the past, but where an innovation has been made in a soft way and then in a more formal way by the international community on internet domain names. So this is a classic issue, but this is a classical issue where the international community arrived already at maturity. And this is a classical issue that also paved the way to other progresses, such as the ones done in your committee. This is why our October 13 Global Digital Encounter will be dedicated to internet domain names, of course, the interaction with trademark, but also interaction with other fields. We warmly thank all participants for their attendance. We hope to see you numerous at our next encounter, and we are happy that our family is now enlarged thanks to the presence of the very brilliant faculty we had the honor to welcome today. All our thanks, and see all of you very, very soon in 1 month's time.